Seated.
This is case number 24CR41416, the State of Ohio versus Aaron Jones. Mr. Jones is present before the court with counsel, Ms. Morton. Mr. Arnold's here on behalf of the State of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before. It's not
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you won't.
Man, it ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and you never know how good you might be at that.
Buckle up, guys. Today we are going to witness a courtroom showdown like no other. From the very start, the narrator sets the stage, teasing us with the antics of a so-called sovereign citizen who thinks the law doesn't apply to him. This intro grabs you right away, promising absurd claims, tense exchanges, and a battle of patience between the bench and defendant lost in his own fantasy.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry?
Cool.
It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I
Ms. Martin does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years.
The case begins and the prosecutor outlines the situation. The defendant, Schuster, has chosen to represent himself. Right away, we see the warning signs. He launches into "I reserve all rights" rhetoric, insisting he mailed affidavits and motions. What should be a routine matter quickly veers into sovereign citizen territory, with Schuster positioning himself as a legal genius while everyone else simply tries to keep the case moving.
I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay. There's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
Are
you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Here, the conflict escalates over discovery. Schuster insists he never received documents, while the prosecutor and court staff confirm they were sent. The conversation turns into a bizarre debate about whether he checks his own mailbox. This moment perfectly showcases a sovereign citizen tactic, turning simple procedures into endless disputes. The tension rises as a court tries to cut through his excuses and keep the process on track.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? Nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
You will be required by law to follow the Ohio Rules of Evidence and the Ohio Rules of Criminal Procedure. Do you understand that?
Yes, sir.
Your lack of knowledge of the evidentiary and procedural rules will not prevent this court from enforcing those rules. Do you understand that?
Yes, sir.
you would understand that your lack of knowledge regarding the rules of evidence and the rules of procedure will result in you waiving the review of those issues on appeal. You understand that?
Yes, sir.
If you have any difficulty in presenting a defense on your own behalf, any difficulty in complying with the procedural rules or the rules of evidence, the court cannot assist you in the presentation of your case in any way. Do you understand that?
Yes, sir.
You understand that the state of Ohio will be represented by an experienced trial attorney.
Yes, sir.
You understand that your right to represent yourself is not a license to abuse the dignity of this courtroom, and thus, if any disruptions during the trial occur, your right of self-representation may be vacated by me. Do you understand that?
Yes, sir.
If you choose to represent yourself when you're convicted, you cannot complain about the quality of your own defense, and it will be basically a waiver of your right to appeal the ineffective assistance of counsel. Do you understand that?
Yes, sir.
Do you suffer from any physical or mental disease or disability?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Has anyone threatened you or forced you in any way to waive your right to counsel?
No, sir.
Have you been promised anything in exchange for your right to counsel?
No, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
A few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
As the addresses are read aloud, Schuster begins to unravel further. He dodges responsibility, claims confusion, and even challenges the court's jurisdiction once again. The judge grows increasingly firm, pointing out his attempt to play games with addresses. What could be a straightforward verification turns into another delay tactic, giving us a clear glimpse of how sovereign citizens twist even the most basic details into chaos.
We'll just jump right back into the dumpster fire, but you're not gonna believe what he complains about next.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
The officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right,
out so I can
let's
wipe.
get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After the presentation of the witnesses by the state and by your side, the defense, we will have closing arguments. Each side will have a few minutes to wrap up their case and present their argument to the jury. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand that I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of. Debatable,
All right.
though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
Can I use the bathroom, please? I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record.
This is where the hammer drops. The judge methodically explains how Schuster waived his right to counsel and must follow court rules as if he were a lawyer. She reviews his motions, finds them improperly filed, and then decisively denies both, ruling that the court does indeed have jurisdiction. This powerful moment shows the futility of his arguments. The suspense peaks as the judge reasserts control, making clear the law stands unshaken.
All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. Just had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
I'll represent myself then.
You want Miss Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the form in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason.
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not,
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself-
removing her was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right, read-
seen my
read-
signature. You already
I'm sorry, I
asked me my
misspoke.
signature. You see my signature was on that shit. You already seen it was there. What are you talking about?
Mr. Jones, read the form. You
Bro,
said you
I already
didn't read
signed
it.
it, man. It's cool. Go ahead.
Read the form. You done?
I ain't read it. I
get the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
to...
Ms. Martin is standing by
Mi-
counsel.
Mr. Jones, I'm going to tell you
Counsel.
Mr. Jones, I'm going to tell you
I'm not
what...
allowed to object. I'm my own counsel now. I'm allowed to objecting, ain't I?
Then you say the word objection.
I did. I said I object.
Yep,
How I'm
what are you
supposed to say it?
objecting to?
I'm
I
objecting to
removed-
Ms.
I've-
Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her was
right, stop.
based on.
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your
All
Honor.
right, bring them down.